Chambers. I am John Chukwuokpata, an attorney. With me is my senior partner, Paul Machukwuokpata. We are planning and environmental lawyers and property consultants. In this episode, we shall dwell on the elements of conservation law practice.
And this time we are going to look at other elements of environmental conservation law practice. And first on the list is that organizations are engaged in compilation of conservation statutes and preparation of model laws for the forests, game, the parks, and the other forms of nature reserve. Then two, organizational housekeeping. It is expected that every corporate entity and the institutions, be it financial, that is banks, or educational institutions as universities, and every corporate organization, it is expected that they have a policy on the environment. It is not limited to a country or to the state, no, but to organizations also. And so the organizational housekeeping involves putting together all the practices, their works, to showcase their practice if it is in line with best practices, going by global trends. And the other areas are the chores of bylaw preparation, the drafting of charters, constitutions, and procedural requirements for parks and recreation organization, and liability for user injuries. Then there is also the state regulatory actions to preserve wetlands, to prevent encroachment of active floodplains, and ensure sufficient open spaces in newly developed areas. So these are areas of practice, and so much is expected in these areas. The regulation of the criteria required by forests. You see, sometimes you find some of these forest reserves are not in a healthy state. Sometimes you'll find problems of encroachment, encroachment into the forest, the public lands, and law is there to attend, to these issues, and it is made pursuant to administrative procedures, including hearings, and there are other legislative activities requiring legal services, such as a review and drafting of policies and legislations, making representations before appropriate legislative bodies, and compiling legal research and lobbying assistance for conservation issues. All these are within the practice. And other areas are conservation lawyers engage with international conventions. So we have been many a times invited to take part in the conference of the parties to the Paris Climate Summit, to the Paris Climate Agreement, and we have always aired our views towards arresting the problems of the global climate. And there are other areas of environmental crime, such as the application of international law on to environmental crime. You see, there are international laws provided which binds all states, all nations that are signatory to it, all nations that are in agreement with the establishment of those international laws, and by so doing, they have ratified and signed, the conventions, and we have so in fact, environmental crime is an illegal act which directly harms the environment. The crimes are liable to prosecution and enforcement with national and international environmental laws and treaties, such as the illegal wildlife trade in endangered species that contravenes the Convention on International Trade in Endangered Species of Flora and Fauna, that is the CITES. And then there is also the smuggling of ozone depleting substances in contravention of the 1987 Montreal Protocol on substances that depletes the ozone layer. These are agreements, and they are laws that have been provided for states that are in agreement with that to enforce. And then we have also the dumping and the illicit trade in hazardous wastes in contravention of the 1989 Basel Convention on the control of the transboundary movement of hazardous wastes and their disposal. Then there is also the illegal logging and the associated trade in stolen timber in violation of national laws. These environmental crimes are liable to prosecution, and Interpol facilitates international police cooperation and assists member countries in enforcement of national and international environmental laws and treaties since 1992. This we have been hearing of arrests, of businessmen indulging in trafficking of elephant tusks, and many have been found apprehended with pangolin scales, and such people are apprehended and then brought to the courts, and there are also other areas of the concerning CITES, that is the Convention on International Trade in Endangered Species of Wild Fauna and Flora. It was signed on March 3, 1973 in Washington, D.C. CITES was signed on March 3, 1973 in Washington, D.C. and June 22, 1979 by contracting states, which Nigeria is also signatory. So, and the CITES recognizes that wild fauna and flora are an irreplaceable part of natural systems, of the earth, which must be protected for these and generations to come, for the present and the future generations, to foster intergenerational equity. You see, the purpose of conservation is to ensure that the future generation also have the opportunity to use this flora and fauna, that they are not, that they don't die out. And CITES is also conscious of the ever-growing value of wild fauna and flora from the aesthetic, scientific, cultural, recreational, and economic points of view. and recognizing that peoples and states are and should be protectors of their own wild fauna and flora. And so, you see, recognizing also in addition that international cooperation is essential for the protection of certain species of wild fauna and flora against overexploitation through international trade. And you see, there's quite a lot to it. And science is also convinced of the urgency of taking appropriate measures to this end. Then at national level, too, the Endangered Species Act, prohibits hunting of or trading in these wild animals, and it regulates their export and import. If you look at the first and the second schedules of the Endangered Species Act, the species listed in the second schedule are regulated, and their import and their exports are regulated. And then secondly, the whole people that traffic or handle some of these species, especially of fauna, should have permits and certificates. For instance, if you should be in the possession of a lion's cub, if you should be in possession of a lion's cub, it is expected that you should have permits, you should have license to that effect, and certificates to that effect. And there are penalties and forfeitures when that is not the case. You are liable to penalties and forfeitures, and also for the purpose of records, for record keeping of this. In fact, we have been hearing that the gorilla, for instance, in Nigeria, that Nigeria is having less than 100 gorillas in the wild, and it used to be 300, but we learned recently that some of these gorillas have migrated to the neighboring Cameroons, and they have crossed the borders of Nigeria into the Cameroons, and that as at this moment about 100 living representatives are found in the country. And yes, and it's our concern as conservation lawyers, and we ensure that these animals that are endangered, that we try to ensure that they don't go into extinction, because there are so many of the Nigerian fauna species, that have already gone extinct, and to prevent that from furthering, to prevent that from happening again, the conservation laws are there to help. And so we also have there are some animals in the first schedule that are absolutely prohibited from hunting, capture, and trade. You see, and these animals, and in the second schedule, trade may be conducted, but other license. So we have seen the difference between those in the first schedule and those in the second schedule. The first schedule, their hunting, their capture, and the trade is prohibited, while in the second schedule, the trade may be conducted, but under license. Please don't forget, subscribe to our channel like our video, share them. You can hit the notification button so that you can receive more, even our newsletters. And then you can also interact with us by commenting on the comment section. And for any help, you can DM us at catventuresng@gmail.com. And we are always there to help you out.